Are you Amanda Arendt? And will your client waive the formal reading of the motion?
She will, Judge.
Give me just a second. All right, so this is 15-23083, and Ms. Arendt.
We jump right into chaos. Mid-hearing, mid-storm, the judge uncovers a 2017 mistake that flips probation into a full conviction. One ruling, one correction, and everything in this courtroom just changed forever.
July 31st of 2017 for the offense of intoxication manslaughter. At the time, that was a 10-year deferred probation, and we have spoken off the record, Mr. Parker and Ms. Malfino and I, realizing that that was obviously an error that took place. And Ms. Arendt, I know Mr. Parker has gone over that with you as well. Is that correct? And so with everyone's permission, it's my understanding that everyone agrees that I go back and modify that judgment from 2017 from a deferred probation to a conviction with a straight probation. Is that correct?
Yes, and I believe, Judge, we agreed to it being 10/10.
Here's the real twist. Deferred probation is mercy in motion. Finish it and you walk clean. But straight probation, that's a conviction. This correction isn't paperwork. It's a rewrite of destiny.
Right, which would make sense. And Ms. Arendt, you've gone over that with Mr. Parker, and you agree. Is that correct?
Yes, I've explained to you about the error of the judgment and what we're doing here today, and we're amending that judgment to reflect what it should have been there, and it's going to be retroactively, so it would be like it happened at that time. You were sentenced to 10 years prison, but you got 10 years probation.
So then, at this time, based on the previous plea and all of the information and admonishments that were given back on that plea date, I am going to retroactively, with everyone's agreement, find Ms. Arendt guilty of intoxication manslaughter, assess that punishment retroactively at 10 years in prison, probate it for 10 years, which gets us here. All of the other conditions, fines, and everything would remain the same. So the judgment from back then will just need to be knocked to show that it was a straight probation with that conviction instead of the deferred probation. Now, with that being said, will she waive the formal reading of the motion?
She will, Judge.
And at this time also, Ms. Malfino, I think it probably, to make it clean, I think the state could orally amend that motion. Let me print it out so I can make that in writing on here.
Here you go.
I'll get one. That's all right. Thank you, though. Go ahead, Ms. Malfino.
And Judge, I would make an oral motion before the court to amend that motion to revoke to reflect the period of 10 years probated for 10 years from back on the sentence dated July 31st, 2017.
There's no objection.
All right, so I will make, with also in the title, with everyone's permission, I'm going to make the modification that just says motion to revoke probation and take out unadjudicated. Is that agreeable? All right. Okay, so now let's go through the motion. Ms. Arendt, in 15-23083, I have a motion to revoke your probation. Shows that you were placed on probation July 31st, 2017.
Now it turns painfully personal. The judge fires off each violation. Everyone met with a soft true. The room tightened. Each word drains her hope. Freedom slipping, second chances fading fast.
Shows now that that was a 10-year sentence in prison that was probated for 10 years. And it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department in Harris County, June 9th of 2021. Is that true or not true?
It's true.
Count 2 alleges that you failed to report to Jefferson County by mail March, May, and June of 2021. Is that true or not true?
It's true.
Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 4 alleges that you failed to immediately report to the probation officer your change of address. Is that true or not true?
It's true.
Count 5 alleges that you failed to immediately report to your probation officer your change of employment. Is that true or not true?
It's true.
And then count 6 alleges that you are behind in your court-assessed fees.
It's true.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Any evidence that Ms. Aaron's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement for a term of 8 years in the institutional division of the Texas Department of Corrections.
And there it is, the breaking point. The judge delivers the words every defendant fears. Probation revoked. In that instant, suspended time turns to prison time. Cold, precise, and painfully final.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. The state is asking that I make an affirmative finding of a deadly weapon. State's exhibit number 2 that's been admitted is the probable cause affidavit that shows underlying offense. Mr. Parker, any objection or comments with regard to that?
Obviously, she'd rather it not be found. I understand the court position, so we defer to the court.
All right, I am going to find that there is affirmative finding of a deadly weapon, the vehicle in this case, and sentence you.
And here comes the knockout punch. Texas law's deadly weapon finding the weapon her car. One phrase locks away parole, brands her record forever. In this courtroom, even metal turns criminal.
That term. I am going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, ma'am. You can go back with the bailiff. Ms. Allen, in cause number 23, DCCR 0639, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 23rd of 2023 for the offense of evading arrest or detention with the use of a vehicle, third-degree felony, and that was an 8-year deferred probation. Is that correct?
Yes, ma'am.
Count 1 alleges that you failed to conduct yourself in a courteous and professional manner at all times, especially when interacting with court officers, staff, probation officers, law enforcement officers, and attorneys, in that you were involved in a physical altercation with fellow inmates September 12th of 2025. Is that true or not true?
True.
Did you enter your plea of true freely and voluntarily?
Yes, ma'am.
And did you plead true to count 1 because it's actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also, state tenders number 1?
No objection.
It's admitted. Any evidence that Ms. Allen's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. Handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Ms. Allen, this gives me no pleasure to do this. But you were told specifically some very specific things about behaving in the Jefferson County Jail. And the fact that you chose to go in there and still continue to fight and be disrespectful after I gave you the opportunity, you gave me no choice but to do this. I hope that you learn that there are consequences to your actions. There will be consequences when you're in TDC. Whether you make parole or not is going to depend on how you act. So you could end up doing the whole 3 years in TDC if you keep acting like this. They're not going to let you out. They're going to have the same types of consequences. Your life, when you do get out, same types of consequences. All right? You can go back with the bailiff.